My lady, my lords, I was going to turn to look at the judgments now, if I may.
Yep.
It is in the core bundle behind tab 9. And as your lordships and my lady would have seen, this was a very long and detailed judgment in which many issues were in dispute below. But for our purposes, the relevant extract is right towards the end, at page 245 of the bundle, starting at paragraph 500 and running to 504. And if I could ask you please to read that passage.
We've all read it, thank you.
Yes.
I mean, when people used to say that to me when I was in your position, there was always that difficult point about how carefully have they read it. So really, what do I need to take them to? So perhaps you'd like to take us to those parts you think are particularly relevant.
My lady, I think it suffices just to make four short points about this.
Right.
This section. The first is quite obviously at this stage, the learned judge, for very understandable reasons, did not refer to any of the authorities that we have looked at today, and that is because the issue wasn't argued in any detail.
Well, he refers to that in the consequential judgment.
Precisely, my lady, yes. And the second point is the one I made earlier, which is, without reference to those authorities, his lordship did acknowledge that in relation to the periods where payments went both ways, it would be unjust for there not to be some form of netting off. And his lordship got to that conclusion via a different route, but as my Lord Justice Popplewell said in argument, one could equally analyse that as a process of netting off, but taking place on a yearly basis. And that was the third point, which is the importance of analysing the transaction as involving independent transfers each year. That is really the crux of the learned judge's reasoning in this passage. And the fourth point is that at this stage, the learned judge was focusing on the benefit received by the college. And one can see that from paragraph 504. His lordship treated the claims as severable because that best reflected the nature of the benefit transferred, which was the possession or use of property over time. But there is, at this stage, no consideration of the substance of the counterpayments that were made by the college in return. And that one sees from the consequentials judgment. So if I could ask you then to go on to the consequentials judgment, which you will also have read, no doubt.
Yes.
And then in that case, may I start by looking, please, at paragraph 20, which is page 257. Now, in my respectful submission, in this paragraph, his lordship does not apply any general principle of counter restitution of the sort which I have submitted to your lordships and my lady. The approach which his lordship took was that there is no one single right order in which to consider the issues, and that whilst there may be cases where it's appropriate to apply the principle which I have contended. There are cases where it is not. But beyond that, that it does not amount to the application of the general principle which I say exists on the authorities. And for that reason alone, this passage contains the first error of law which I set out above. The counter-restitution principle is treated as being a case-by-case inquiry, and the principles which ought to guide the answer in any given case are not identified in this passage. Now, it may be helpful to look at how my learned friends explain this in their skeleton, how they characterise the test which the judge applied. It's at tab 7, and it's paragraphs 6 and 7 on page 61.
Yes.
And in those passages, my learned friends suggest that there isn't any principle of law, overriding principle of law in this area. The question is simply what is just on the facts of a given case, and that gives rise to a question similar to discretion. And for all the reasons that I submitted earlier, in my respectful submission, that is not the correct approach to a question like this in a claim for unjust enrichment. There is no suggestion that the swapped cases were applying a form of discretion or simply asking a generalised question as to what was fair on the facts of a given case. And that approach would be inconsistent with Lord Reed's statement of principles in the investment trust case, that unjust enrichment claims do not fall to be resolved in that way. A principle must be identified in this area of the law. And in my respectful submission, it is the principle that I identified earlier. Now, it is necessary then to go on to look at the second of the issues, which is in many ways the most important, which concerns severance. Because as my Lord Justice Popplewell said earlier, one way to look at what the learned judge was doing here was to apply the counter-restitution principle, but to define the transaction by reference to each year in which there was occupation of the building, rather than by reference to the contract as a whole. And if one just looks at paragraph 24, that is where one finds the crux of the judge's reasoning. My lords, this passage gives rise to two questions, and the first is, what are the relevant principles for characterising the relevant transaction for the purposes of the netting off process? And the second is, in any event, applying those principles, was this a case on the facts as found by the judge where each year ought to be considered a separate transaction? And although it's taking the issues out of turn, I was going to start with the second of those points, because it is my submission that on the findings of fact by the judge, it is plain that the payments made in each year were not referable to and only to the occupation of the premises for that particular year. And that is because this was not an operating lease. This was a finance lease. And under a finance lease, the payments are in substance repayments of capital and interest. And the fact that they happen to be staged by way of annual payments over 15 years does not affect the proper analysis of this contract. And so if I might make good that point by reference to the judge's findings in the judgment, starting in the main judgment at paragraphs 55 to 60. On page 91, and this is where the learned judge records the terms of the contract. And if I could ask, you may well have read this already, but if I could ask my lady and my lords to read 55 through to 60. My lords, this was very far, even just looking at the terms of the contract alone, very far from an operating lease. This was a situation where, to all intents and purposes, the college assumed the risks incidental to ownership of the property in return for the payments. The college was liable to insure the property for the costs of inspection, loading, unloading and transportation, and for ensuring that it complied with applicable statutes and regulations. And hire was payable even if the building couldn't be used for the purposes for which it had been conferred. And finally, in the event of an early termination, the net present value of all of the lease payments became payable upfront and immediately. Now, those are the contractual terms. The next question is to look at the judge's findings as to the nature of the contract. And
do we also need to have in mind clause 2.3.1, which I don't think the judge refers to expressly, which identifies that it's on page 349 of our core bundle behind tab 17, which provides that the colleges will be entitled to quiet possession and use of the equipment, provided that it performs all of its obligations under this contract. So that one has there an express link between the benefit we're here concerned with, namely continued use of the building, and performance of all its obligations, which include making the annual payment of hire in advance.
yes, but do not just include that obligation. So, in my respectful submission, 2.3.1 does not tie each payment to use for only the period in which the payment is made. It's simply making the point that in the event that the college fails to perform any of its obligations, it's no longer entitled to the use of the building. And in the event that the college does cease to be entitled to use the building, it has to not only, it has to pay all the net present value of the future rental payments, as well as those relating just to the period in which the property was used. Now, I was going to go on to para 180 of the judgment. Which just sets out the nature of a finance lease. And that's at page 138. And if I could ask you please to read that.
I'm so sorry, I missed the reference.
It's page 138, paragraph 180. So the hallmark, as I said at the outset of my submissions, of a finance lease is that in substance it involves the acquisition of an asset by means of a loan, which is then repaid with interest. And that is the question that the learned judge was asking himself: is this contract of that nature? And in the following sections of the judgment, his lordship addresses that question in detail, and reaches the conclusion that yes, this is clearly a finance lease. And it, for present purposes, it's probably sufficient to just look at paragraphs 249 and 250 of the judgment at page 160. And so, my lady, my lords, the judge was in no doubt that there was a clear answer to this question, that the contract was a finance lease, and it therefore was a form of borrowing. And that is the whole point as to why it was void from the outset. Now, in my respectful submission, it follows from that the payments in each year were, in substance, on the judge's own findings, repayments of capital and interest. They were not, in substance, rental payments, only for each. They were not, in substance, payments for the rent of the building for each year. And so for that reason alone, it can't be right to view them in that way and to split this transaction up into individual years. This was a single transaction under which the college acquired the building. And in return, it paid 15 yearly repayments of capital and interest. And the transaction as a whole needs to be looked at for the purposes of netting off the benefits going both ways. And one can test that by standing back and looking at the significant disparity between the judge's findings as to the market value of the property, of the use of the property for each year, and the payments that were in fact made. Because the judge assessed the market value at in the region of £250,000 per year. The college made payments of in excess of £800,000 for each year during the end of the contract, and as high as £1.2 million at the start of it. Those payments were not, on any analysis, payments for the use of the building for a single year. And so, for that reason alone, whatever approach one takes to...
So I'm not understanding that point. The disparity between the hire charges and the value of the building shows your submission that the hire charges can't have been paid for the use of the building.
It shows in my submission that there must be an element of finance costs involved in the transaction, and that is what explains the significant disparity between the market value and the repayments that were.
Well, it may just be not a very good bargain. It's not unknown in PFI contracts.
No, my lord, that is...
I'm sure one can draw a conclusion from that.
My lord, in one sense, though, the nature of the payments, the extent of the payments were one of the reasons why the judge concluded that this was a finance lease, because the level of the payments meant that one of the threshold tests for whether or not there's a finance lease was satisfied. But the point I made was simply just to support the judge's conclusion, which is in any event evident from his reasoning. And so, for that reason, however one approaches it, the answer is, in my respectful submission, clear from the judge's findings that each annual payment cannot be looked at as being referable only to the benefit received in each year.
What would be the position in year 16? I know you describe it as a 15-year lease, but it isn't. It's a minimum of 15 years and may continue thereafter. Hire charges are due in year 16.
In accordance with...
And year 17 and year 18, and indeed they may be increased by SFM up to the retail price index.
Yes.
And indefinitely thereafter.
And so the position would be the same. That would be, in substance, a single transaction.
But my question really is, to what extent, I can quite see that in a classic financing lease with an option to purchase at the end, the hire is not really hire at all.
No.
But here you have no option to purchase at the end, and you have 15 years not as a fixed term, but as a minimum term in which the contract contemplates at least that the buildings will be of use thereafter and will have to be paid for thereafter. It may be more difficult then to treat the hire charges as the equivalent of the financing cost of purchasing when they are to continue for an indefinite period.
But on the judge's finding, that is necessarily what these were, and that issue isn't live anymore on this appeal. This was a finance lease, and so these payments must have involved an element of repayment of financing costs. Otherwise, this wouldn't have been a borrowing contract at all.
All right.
And so, from the college's perspective, what was contemplated was that at the conclusion, as one sees from the side letter, at the conclusion of the 15-year term, there may be a transfer, but that was not legally binding. One has to accept that. So from the college's perspective, it was committed to paying financing costs indefinitely.
Thank you.
Well, I said there was also an issue as to what the correct test is for characterising the transaction and for the question of severance. Now, it may be that issue doesn't arise in view of the nature of the judge's findings as to this particular contract. But you will have seen from the judgment that the judge applied the approach in Goss and Chilcott, which looked at severance for the purposes of answering the question whether there was a failure of consideration. And my lady and my lords already have my submission that that question is not relevant in a case like this, where the contract is void from the outset. And that is the Guinness-Marne case that I showed you before lunch. And so that test is not the right test in this context. But as I accepted in exchanges with my Lord Justice Popplewell, it may still be necessary to define the transaction and for the purposes of assessing the element of mutuality in the particular case. And in my supplemental skeleton, I have set out the authorities which address a similar question in the context of rescission. And so a question does often arise in rescission as to whether the requirement to give counter restitution should be defined by reference to the contract, the relevant contract, or by reference to more than one contract, or in exceptional cases, by reference to multiple transactions within a single contract. And I've set those principles out at paragraph 10 of my supplemental skeleton. I was not going to go through them. I do not understand, my learned friends, to say that that's not right in the law of rescission, so that summary isn't accurate. The only point that's made is that those principles don't apply where the contract is void. They only apply where the contract is voidable. And in my respectful submission, that cannot be right. In both cases, one is concerned to ensure that there is counter restitution. In both cases, there's been a mutual exchange of benefits. And so in both cases, the question arises as to what the relevant transaction is. And so in relation to this question of characterising the relevant transaction, I do say that one should be guided by those principles and not by the severance principle described in Goss and Chilcott, which was addressing a different question. Now, my lady, my lords, that just leaves the third and fourth of the points that I opened with. And the third point arises out of the consequential judgment at paragraph 25. And that's at core bundle, tab 9, page 259. And if I could ask you to read that paragraph. This is the paragraph concerned with the timing point that we debated earlier. The first point I wanted to make in relation to this is it is unclear to what extent it had independent force in the judge's conclusion, because obviously the anticipatory change of position in this case occurred right at the outset of the transaction, and so it obviously preceded all of the payments that were made by the college, including the payments that were made in the first period before payments ceased to be made. And the judge still applied the counter restitution principle in the substance during those earlier periods. So the fact that the change of position was preceded receipt of the relevant benefit did not preclude those earlier years being netted off in substance. And if the judge had viewed the transaction as a whole, then it is unclear whether this paragraph would have had any, would have continued to have any force at all, applying the judge's logic. The second and more fundamental point, which I made earlier, is that there is no principled distinction between as to when the disenrichment occurs. Now, it is well established, and the judge himself referred to this, that there can't be a technical distinction between the two for the purposes of change of position. So it is well established that a defendant can rely on a change of position that occurs before receipt of the benefit and also after it, provided that in each case there's a relevant causal link. And to view it any other way would be a triumph of form over substance. Now, in my respectful submission, the same point must surely apply to the counter-restitution principle. It simply cannot matter when the change of position defence occurs. What matters is, first, what is the net benefit received under the transaction? And second, is there a change of position in relation to that net benefit? And that change of position may occur before receipt of the benefit or after it. That doesn't matter, provided there is a relevant causal link.
But that formulation assumes that the change of position doesn't affect the question as to whether there has been a counter benefit at all.
Now, on that question, which we debated earlier, my lord, that doesn't necessarily assume that. It all depends on what one means by enrichment for this purpose. And the general approach, in my respectful submission, is enrichment is characterised by the receipt of the benefit conferred under the transaction. At the first stage of the inquiry, it is not characterised by looking at the defendant's global position.
Will you describe it as the global position? One of the things which you haven't mentioned, but we have to keep in mind, is the nature of the change of position, which is 5 million plus paid up front. So that SFM are permanently out of pocket,
yes,
even when they receive the hire charges. So that if one is looking in those circumstances, and this won't necessarily apply to all change of position defences, but if you're looking in those circumstances at whether the hire charges confer an enrichment, i.e. a benefit, your submission that one ignores the global position and looks only at the position under the contract has to come up against, doesn't it, the nature of the contract, which has on its very face, we the college request you, SFM, to incur the building costs. That's not extraneous to the contract. That's part and parcel of this contract. Now,
my lord, that question doesn't go to the timing point. That consideration goes to the fourth, the next of the judge's reasons, which was the wholly extraneous point.
No, it goes to the question as to whether there's a benefit in the first place to net off.
Now, in my respectful submission, it doesn't. It goes to that the fact that payments have been made is relevant, if at all, to a change of position defence. It's not relevant to the question whether there has been the receipt of a benefit under the contract, which in this case there clearly was. And the timing point doesn't go to that, because one can test it this way, my lord. Suppose that the construction costs were incurred 2 hours after the first benefit was received, rather than 2 hours before it. And it wouldn't make, in my respectful submission, any sense for the answer to the enrichment question to be different in those two cases. In both cases, there's an enrichment. There is then subsequently, in one case, and in anticipation in the other, a change of position.
Part J Lord Templeman in Lipkin Gorman, who treats change of position as referable to enrichment.
Yes.
I mean, the reasoning he gives in his example in Lipkin Gorman of the justification for change of position, he gives the example of a thief who gives £20,000 to someone who spends it on a car.
Yes.
In circumstances where he wouldn't have bought the car if the gift had not been made, and therefore there is a change of position. And he says, well, if the car still has a second-hand value, that has to be brought into account,
Yes.
because there's only effectively a net enrichment. There's only a net benefit. There is a benefit to the extent of the residual value of the car.
Indeed.
Now, if that's the explanation for what in that case, that example was subsequent benefit,
Yes.
then why does it not come in at the stage of deciding whether there is a counter benefit before you do any netting off?
So, the difference between that example and the example we're concerned with is that this is a bilateral transaction, so benefits have flowed both ways, and there has been a change of position. And so in that situation, one is concerned first to work out what the net benefit is, in my respectful submission, and then to look at whether either the relevant party has a change of position defence. Now, it's quite often straightforward in a case where benefits only go one way because no question of counter restitution or mutuality arises in that case. And the explanation for the example which my lord gives is that there is an enrichment when the money is received or the thief steals the money, but then there's a disenrichment when the car is subsequently bought, and there is a change of position defence to the extent of the difference between the money that was stolen and the value of the car. And that separate question, this enrichment question, goes to a defence change of position.
Well, not in Lord Templeman's analysis.
No,
That's what I'm putting to you. He treats it as a question which simply goes to the fact of enrichment,
Yes.
which is the first of our questions,
Yeah, and
which logically one needs to decide if you're then going to start to net off benefits that qualify.
And in my respectful submission, it's clear from the analysis of Lord Gough in Lipkin Gorman and from the treatment that one finds in the textbooks that change of position isn't seen as just part and parcel of the first question. It's a defence.
Well, he treats it as part of the second question. What is unjust? Is the enrichment unjust?
Yes.
But I'm not sure that helps you particularly in suggesting that you go straight to netting off before you go to change of position.
Well,
Because even if it's a question of injustice, then logically one might say you're looking at whether there is an unjust enrichment which needs to be netted off.
Yeah.
And then, therefore, if the change of position defence goes to the justice of whether an enrichment, a counter-enrichment, does or doesn't need to be taken into account, that's stage 2 of the 4-stage test.
well, my lord, that analysis would, in my respectful submission, assist me because the counter restitution principle, which we looked at earlier, is in my submission a question affecting the first question, the enrichment question. And that's undoubtedly what Mr. Justice Hobhouse was doing. He was saying in a mutual exchange transaction, there is only ever one benefit received, it's the net benefit, and that's the enrichment with which we're concerned. So that would always be the first question. And then insofar as change of position comes in, it affects a subsequent question, which is whether the receipt of that benefit is unjust. And so your lordship's formulation would, in my respectful submission, be of assistance to me and would support the approach for which I contend.
Because your netting off has appeared at the start,
Yes,
and you're only arguing about the balance.
yes, my lord, yes.
And then they say, well, we paid 5 million to get this, and you say, okay, well, I can't get any more back.
Indeed, my lord.
Yeah.
Lord, finally, that then leaves the judge's fourth consideration, which to an extent I've touched on already, which is that in this particular transaction, the change of position was incurred in order to provide the benefit to the college, namely by purchasing or acquiring the building. And should that affect the analysis? And in my respectful submission, it doesn't. That is not part of the transaction with which we are concerned in this case. The transaction is the hire contract, and that is the contract which must be unwound. And in any event, it is unclear that the judge's reasoning depends upon an analysis that the disenrichment was not wholly extraneous, is the words used by the learned judge. And it is unclear to what extent, in what circumstances that consideration would be engaged. Obviously, there are extreme examples. For example, where a benefit is stolen, that could be described as wholly extraneous. But in many cases, the position will be much more nuanced. And one can take the swaps cases. There were, in those cases, many back-to-back transactions which were designed in one way or another to enable each party to enter into the transaction and to provide the benefits which they provided. But that did not affect the analysis in any way. The learned judge looked only at the transaction with which he was concerned, and namely the void swap, netted off the benefits, and then, to the extent relevant, considered a change of position. Two further points in relation to this. The first is that it is difficult to see how this principle sits with the fact that even a fraudster can insist on counter restitution. Now, a fraudster can say, well, you can't unwind this transaction without giving me back what I conveyed to you. But in our case, there is clearly no question of the council having acted wrongly in any way, of the college having acted wrongly in any way. These are two wholly innocent parties who conferred benefits on one another. And the fourth is that although it's clear on the face of the contract that SFM was requested to acquire the building, there is no finding by the judge that SFM knew the detail of the arrangements that lay behind that, and as to what payments would be made, when, or in what amount. And so, my lady and my lords, drawing the threads together, in my respectful submission, there are 4 reasons why the judge erred in law in considering this question, such that this court should set aside the judgment on this particular issue. And that then gives rise to how those principles ought to be applied to the facts of this case. And in my respectful submission, the answer to that is as follows. First, one starts with the principle that there should be counter restitution of the benefits conferred under the relevant transaction, and they should be restored, they should be turned into a net benefit. That then gives rise to the question, what is the relevant transaction in this case? And for the reasons which I have enunciated, there is only one transaction. It is the hire contract, and it should be looked at as a whole. And that means that in this case, there was only a single claim by the college against SFM for approximately 1.5 million, to which the change of position was a complete answer, such that the claims should have been dismissed both ways. And unless I can assist my lady and my lords, that's all I wanted to say by way of opening.
Can I just ask one question? It's really definition. Because I've seen counter restitution used in a number of different ways. How would you define it?
In what sense?
The actual definition of counter restitution for the purposes of a judgment. Because, I mean, it gets used in different ways in different authorities. I just wondered, well, do you have a working definition? And if so, can I use it?
Yes, I would refer to it as a counter restitution principle.
No, what the meaning of it?
Right, yes. It is that where benefits have been conferred pursuant to an exchange transaction, then those benefits must generally be netted off against one another, leaving a single claim for the net benefit against the party who has received it.
Thank you. And that then includes the exchange transaction as part of the definition?
Yes,
Yeah.
indeed.
Sorry to ask you that.
No.
Thank you very much.
Thank you very much indeed. Yes.
Lady, my lords, we reached the nub of this appeal just a few minutes before lunch when my Lord Justice Popplewell put two critical questions to my learned friend, Mr. Watkins. First, my Lord asked my learned friend whether it was right that the question whether a given contract or transaction consisted entirely of mutual exchanges depended on the context, and my learned friend agreed that it did and accepted that in some circumstances it might be right, it would be right in some circumstances, to analyse what he called a single transaction as involving more than one exchange. Secondly, my Lord asked my learned friend whether Mr. Justice Foxton was applying the counter restitution principle, but only to what he regarded as the mutual exchange. And my learned friend again accepted the point that this was indeed what Mr. Justice Foxton was doing. Now, my lady, I agree with both the answers that my learned friend gave, so that's a good starting point on common ground. And based on nothing more than that common ground, it follows that the real question in this appeal is whether the judge's analysis of the benefits that passed between the parties was an analysis that was open to him on the facts. And that's a question of the overall assessment of the facts, in respect of which this court will give considerable deference to the view of the trial judge, a point which my learned friend has not sought to address, despite it being front and centre of our two skeleton arguments. My learned friend has addressed the judge's analysis this afternoon after lunch, and I will respond to that in just a moment. But if one starts by recognising that some transactions may involve separable exchanges of benefits, and that the judge in this case was engaged in the exercise of analysing whether this was such a transaction, then my learned friend's very learned, and I say that with no imputation of disrespect, exegesis of the authorities this morning is really of quite limited relevance. I will respond to it, of course, but I will do that after I've looked at the judgment. It's important to bear in mind that the relevant claim for present purposes is my client's claim for restitution of the benefit of the use of the buildings which it conferred on the college for the period from the 5th of September 2013 up until the date of the trial. As I'll show you in a moment, the judge was careful to draw the line at the date of the trial. And that benefit was an enrichment conferred by my client upon the college pursuant to a void contract, which is not, of course, a contract at all. And one of the places in which my learned friend's argument goes wrong is in seeking to analyse the benefits strictly by reference to what is now known not to have been a contract. There's no dispute on this appeal that the judge was entitled to quantify that benefit, as he did by accepting the college's submissions about the market value of the use of the building during that period. And there's also no dispute that as a successful claimant for restitution, or otherwise successful claimant, SFM was obliged to give counter restitution as a condition of obtaining relief. Can we start with my answer to my Lord Justice Dingemans' last question, which is what is the counter restitution principle? I say, and I've quoted it in my skeleton argument, but I say it's one acceptable formulation is set out by Goff and Jones, and maybe you'll find it more persuasive if I show you in Goff and Jones rather than in my skeleton. which is in Authorities 3.
3.
3, yes, the third bundle, tab 33. And a few pages on in tab 33, at page 939 of the bundle, we've got the start of chapter 31. And in the first sentence, Jones states, the claimant who seeks restitution of an unjust enrichment must make counter restitutions of benefits received from the defendant in exchange. Now, my lady, my lords, for the purposes of this appeal, the critical words are the last two, in exchange. There are cases where there's no real difficulty identifying the benefits that the claimant received in exchange. In exchange here meaning in exchange for the unjust enrichment which is being reversed at the claimant's suit. And that's what it means. The claimant for unjust enrichment is obtaining the reversal of that unjust enrichment by the order of the court and must give counter restitution of the benefits that claimant has received in exchange for that unjust enrichment which is being reversed. And as I say, there are cases where it's quite straightforward to say what's been received in exchange for the benefit that's being reversed. And in my submission, although the length of the authorities may not bear out that everything was straightforward in those cases, in my submissions that includes an interest rate swap, certainly of a vanilla nature, in which there are simply exchanges of money, one way and the other, through the period of the swap, pursuant to a purely financial contract. But there are other cases where it may be an issue precisely what benefit was received in exchange for the enrichment which is being reversed, and this is one such. So in this case, the judge is finding that my learned friend has to persuade your lordships to overturn, my lady, is the finding that the benefit that was received by SFN in exchange for the use of the building during that period was included within the payments in period 1 that was attributable, we say, to the market value of the use of the building in that period and nothing more. And we'll look at the judgment in that in just a moment.
I think, to be fair to him, he goes a wee bit further and says that the judge's real error was in attributing each year as an exchange transaction, when in truth, on the judge's own findings, it was a composite transaction. I hope I summarise it fairly.
Yes, he does, and in a sense, there's no dispute that what happened was a composite of a number of things, and we need to look at how the judge then analysed it. And in my submission, I know there's one sentence where the judge refers to annual payments, and of course, and I'm going to show you why he does that, because you haven't been shown yet as to what that reflects, apart from some of the terms of the contract which you have seen. But it reflects more of the evidence in front of him as well. But it actually doesn't really matter whether you divide it up, as I think my learned friend was suggesting you could do, between capital and interest repayments of the finance part of this finance lease and payments for the use of the building. Whether you divide it that way, or whether you divide it year by year, you actually get to the same answer, which is the judge's answer. So my learned friend has to go even further still and say, as he did say, the only benefit that the college got was the purchase of the building. He called it an acquisition at one point. That's not the effect of the judge's finding that the document was a finance lease. The effect of the judge's finding that it was a finance lease is not that it was an acquisition, which is a legal term, but that it transferred substantially all the risks and rewards of ownership. That's not quite the same thing. And of course, certainly once it's reversed, the benefits did not include ownership of the building, but they did include use of the building. And so that's the point. My learned friend has to go even further and actually saying it's not just a composite transaction, but my learned friend has to put it in the way he did, that it's a simple transaction for the purchase of the building. But that makes no sense at all once you reverse the contract, because it clearly wasn't a contract for the purchase. There wasn't a purchase of the building. The building no longer belongs to the college. It never did, but it certainly doesn't now. So, my lady, my lord, he has to go even further still than my lord is putting to me.
I'm not sure I'm following that. Forgive me. Is it not enough for his argument to say that the exchange, the mutual exchange for the benefit of the use of the building in the period from 2013 onwards was at least in part reflected in the hire charges in the earlier period, because the hire charges in the earlier period cannot be treated as exclusively referable to the hire in the earlier period. And if you were right about that, would that not be sufficient for his case?
It may well be what he says, but he's not right about it, because, and the reason he's not right about it is because of that, the middle stage between his stage of saying it's all just a single acquisition, and on the other hand saying it's just a hire, which is what the judge in fact is doing, as I'll show you in the judgment, which is dividing up the payments into those which the judge attributes to the periodic use of the building, which is the figure that the judge finds to be the value for that, which is certainly one of the benefits the college obtained, and the other part of the payments, which related to the void part of the transaction, the part which made the contract void, namely that it was in substance a finance lease, which are the payments for finance. And the
I follow. So that it's the difference between the use value as found by the judge and the contract payment by way of hire charges is itself a split between that which is referable to use and that which is reference to financing.
Yes, exactly.
Is that what you're saying?
But yes, so in period one, you've got some payments coming across for the use of the building, some payments coming across for finance. In period two, you've got no payments at all. Period two being after the college stopped paying. And that's the critical period.
Can I just ask you something on the ground, just from a very common law perspective, but looking at restitution, mean profits, there have always been ways of adjusting these matters. If properly analysed, this was a contract under which it fell away and it was a void contract, no one had acquired any rights. Once the college continues to use it without paying, wouldn't you have a straightforward claim for mean profits, which would amount to what the judge has awarded?
Your Lordship may well be right that that's another way of putting it. I don't think...
Because it just helps with what is unjust. It might help with whether it's severable or not. But I don't know whether that works on the facts, because you know the facts in a way that inevitably we can't at this stage.
My Lord, I don't think I can give you a confident answer at this stage as to whether that claim...
Well, we've got 2 days.
would have been a better way of putting it. I'll look forward to having a look at that tonight. My lady, can I make a slightly cheeky request? The light in front of your ladyship is shining right in my eyes when I try to engage with the court.
I'm so sorry. It's broken, and my apologies, because we tried to adjust it this morning.
Well, not at all. Thank you very much, my lady.
This really isn't meant to be an endurance test.
Never known you to retire from the spotlight before.
I'm very grateful. Now, my learned friends, I'm not going to. I won't bore you with the grounds of appeal. There was only one paragraph, paragraph 5, at core page 16 of the grounds of appeal, which then got unpacked in the skeleton argument into 2 points of law. One was that there was an immutable rule of law that all benefits under a single contract or transaction must be treated as having been received in exchange for each other for the purposes of counter restitution. Now, as I understood his oral submissions, my learned friend retreated from that as an immutable point of law, but said that while it was an issue for the judge to decide, the judge got it wrong. The second immutable rule of law was that counter restitution must be considered before change of position. And as I understand it, Mr. Watkins does maintain the position that that is an immutable principle that my lady and my lords should state and introduce into the law. It's important to identify the fact that my learned friend has to succeed on both of those points to win the appeal. One of them on its own would not be sufficient for him, and I say he's wrong on the both. And as I promised, I want to go next to the judgment, and then I'll come to the authorities. So if I could invite you again to, well, in a moment I'm going to invite you to open the judgment actually. Just before, I'm going to open one other document first. So just to recapitulate, as you know, my learned friend has showed you the hire contract was held to constitute a finance lease as a matter of accounting standards. It was therefore held to constitute borrowing within the definition of the Education Act and to be beyond the powers of the college, so it was void. The benefits on both sides of the transaction of whatever had been exchanged therefore fell to be reversed. And as you know, the college made payments in accordance with the contract up until 2017 and then ceased to do so. Now the judge does not make findings about exactly what happened thereafter, but I want to show you one paragraph from the evidence to give you just the outline of that, which is also responsive to my Lord Justice Dingemans' question to my learned friend this morning as to what's the current status of the building. What mattered to the judge was what was the status at the date of trial. And as I say, while he doesn't make findings, I can justify the existence of the supplemental bundle by inviting you to turn in into tab 1, or at least one tab of it anyway. Tab 1 is the witness statement of Mr. Spring of my clients. And can I just show you the last paragraph of page 18? I just invite you to read paragraph 88, please.
Was this a subject of cross-examination?
My Lord, I did check. I don't believe so, my Lord. I wasn't at the trial, but I did check before inviting you to look at this. And as far as I understand it, this paragraph is not particularly controversial as a statement of what happened. Although, as I say, the judge does not make an explicit finding about it. So I don't believe there was cross-examination on this as certainly as primary fact.
Well, that actually ties up a bit with mean profits, doesn't it?
Yes. Can I now invite you to put away the supplemental bundle and go back to the core bundle and look at the judgment at tab 9. Starting at page 213 of the bundle, just to identify, that's the beginning of the consideration of my client's claim in unjust enrichment.
I'm sorry, it's my fault, I missed the reference.
Page 213 of the bundle.
Thank you.
Paragraph 403, just the beginning of the consideration of my client's claim to unjust enrichment. And then, as you know, paragraph 412, the judge concluded that SFM was the proper claimant, and at 424 that the claim was not defeated by the argument that SFM took a risk that the contract might be ultra vires the college. Then the judge turns to the valuation of the claim, and he essentially accepts the defendant's version of that. But we need to just pause on paragraph 428 on page 221 in the course of that consideration of the value. And the judge says he's unable to place any significant reliance on the contract price for several reasons, and he gives 4 numbered reasons. And in particular, if we could look at the second, there's a significant difference between the terms under the contract, under which the college had the benefit of a 15-year period as hirers, and the circumstances which prevail in the absence of a contract, in which the college's use of the building is subject to the risk that BOSHire or SFM might request its return on reasonable notice at any time. So, and this is part of the point I briefly made earlier, that my learned friend goes wrong in his analysis in trying to analyse the benefits once one removes the contract in purely contractual terms, and because actually the benefit is a different one, and it relates to the use of the contract, as the judge points out here, essentially at sufferance. Third, as the judge says, it's important that the valuation of the claimant's unjust enrichment claim remains consistent with the basis upon which he's found that the contract was beyond the college's capacity. I found that the contract was a finance lease because substantially all the risks and reward of ownership were assumed by the college. In valuing the benefit which the college received for the purposes of the claim and unjust enrichment, the price payable under a contract which the college lacked the capacity to enter into is necessarily a poor guide to the value of the benefits it did receive. For the purposes of the claimant's claim and unjust enrichment, those benefits fall to be valued on a fundamentally different basis, namely the benefits of a kind for which the college could have obtained by way of an operating lease, with the result that the economics of the benefit being valued are fundamentally different from those inherent in the contract. So that's where the judge, at first, I think, certainly first in the paragraphs I've shown you, divides the effect of the transaction which occurs when you strip away the contract between that which could have been done lawfully, namely an operating lease, some of the incidents of which, of course, took place, namely the use of the building by the college and the payment for the same, from the incidents of the contract had it been upheld. And fourthly, in this regard, it's significant that while the use of the property can constitute the transfer of benefit for the purposes of a claim in unjust enrichment when a contract for hire has been found unenforceable, no claim will be allowed where this would be inconsistent with the policy that led to it being void in the first place. And then he refers to Diamond and Lovell on that point. In this case, the contract was void because it amounted to a finance lease and therefore borrowing. It would not be inconsistent with this finding to value the enrichment by reference to the market price of the right to use the building under an operating lease. However, the ultra-virus nature of the contract counts strongly against any use of the contract hire rate as evidence of market value. So he's drawing the distinction there between the rate under the contract, which was the payment for what he had held to be effectively finance which never happened because there was no loan of money and the contract turned out to be void, and what could have been done, and what in fact was done once you take away the contract, which is namely effectively an operating lease for a period. So he draws that vital distinction of 428. He then accepts the defendant's expert evidence as to the actual value and reaches that conclusion at paragraph 431. He reaches, and 431 he reaches that conclusion, and at 432 he notes the issue of the interaction of the claims to which he'll return. At 433 he turns to the issue of the claim being only up to the date of the trial, and you can see at 434 that while he doesn't make explicit findings about that passage I showed you from the witness statement, it was his understanding that as at the date of the trial, the college was insisting on retaining the building. So there's a finding there effectively consistent with the evidence I showed you. And then at 437, he refers to the nature of the benefit conferred on the college. And he says, if a claim in unjust enrichment is hereafter pursued in respect to the period after judgment, it might be argued that the college's continuing use of the building does not involve a separate independent transfer of value. In my view, the preferred analysis is that where the benefit conferred is not the transfer of property outright, but the transfer of the right of possession and the concomitant right of use of property, which the transferor is entitled to terminate at will, it is appropriate to treat each period during which the right of possession and use subsists as an independent transfer of value. That will be consistent with the fact that the objective valuation of the benefit is itself time-dependent, viz. A market rate for use for a particular period. And that's very different from the position where there's an outright transfer of money or property. So again, the judge is developing this point that the valuation he has put on the benefit received by the college, in line with the college's own submissions, is itself a time-dependent benefit to do with the use of the building, which is what the college was left with after the contract is declared void.
Can I just ask a question? So this building never attached to the land; it was always capable of being moved away.
My lord, yes, there's material in the judgment about how easy or difficult it was to move it away, because that was part of the argument as to whether it was a finance lease. The accountants, I think they have had surveying evidence as well about exactly how much it would cost to move it. And part of the argument that it was a finance lease was, well, in practice it would be very difficult to move it, and nobody else would want it because it was so bespoke. But it certainly was possible to move it.
So it never became a sort of fixture as opposed to a fitting.
I hope I'm not going beyond the evidence if I say I don't believe it have foundations or matters of that nature. It's described as a modular building.
Yes.
Yes, I see nodding behind me, so I hope I'm not.
Well, it would have needed foundations for services, but they wouldn't have been yours, as it were.
Yes, that must be right. Yes.
I mean, I may have got this completely wrong, but when I read the phrase modular building without any background whatsoever in this sort of construction field, I read it as having the potential to move should it be necessary.
Yes. Well, my lady, I understand it that way, and as I say, there is some material in the judgment. I don't have the references to hand. It's in the section about whether it's a finance lease. There's some material about the cost of moving it.
Yes.
But it could have been moved, certainly. Yes, I think it is fair to say it didn't attach to the land.
And am I right in recollecting that the contract terms specifically provide that upon termination it is to be returned?
Yes.
At the expense of the college.
So, I'm sure your lordship probably is right.
Which contemplates
absolutely
it being capable of that occurring.
I mean,
I may have misrecollected that, but
all parties, when this was entered into, were very conscious of the requirement that it's not a finance lease. So the contract will be phrased in a way to look like an operating lease, because everyone was very conscious, but on both sides of the transaction, that it must not be a finance lease.
But
Yes,
they just didn't succeed.
No.
They just didn't succeed.
I think 2.3.6 was what I had in mind.
Yes.
Upon termination of the hiring of the equipment, however arising, customer will redeliver the equipment to BOSHire. Customer should be liable for all costs of inspection, loading, unloading and transportation of the equipment.
Yes.
So in some respects, you can accept that all Mr. Watkins says and say, yeah, net it all off because it is one transaction until we will work out its void and you stop paying, and then you have to pay for the fact you didn't give it back. And the judge has valued it for us.
In a sense, yes, my lord. I think Mr. Watkins' point, obviously, is to say that if you net it off, you have to attribute that to the second period. But your lordship's right in the way you put it to me. As long as a division is made for the second period when the college continued using and made no payments, then yes, I can accept any netting off, and it doesn't damage my position. And indeed, that is the effect of what the judge did. My lady, my lords, then on page 225, paragraph 441, the judge turns to the college's claim in unjust enrichment, and the benefit conferred by the college was, of course, cash payments, and they're easy to value and reverse, but SFM had a change of position defence because they'd paid over £5 million, as I know my lady and my lords have in mind, to obtain the building and deliver it and erect it at the college's request. Now, the payments with which we are concerned in relation to the college's claim are set out in my learned friend's skeleton argument in Annex 1. So he sets out there the 5 payments which survived to form part of his netting off claim. So at the very end of his skeleton argument, tab 2, you've got there 5 payments. And there's no dispute about that. But if we look on, if we maybe keep half a finger in that, maybe you don't need to, but in the judgment at page 226, the judge sets out a list of payments, a longer list of payments, and gives them letters. So as my lady, my lords, see that on page 226 of the bundle. And the letters that correspond to the five that my learned friend relies on are D, G, H, I, J. So D and G through J. And the dates and the amounts marry up. I don't believe this is a controversial submission. Now, so there's 5 invoices that we need to look at to understand exactly what it is my learned friend is saying should be netted off. Invoice D is described by the judge at paragraph 448 of the judgment on page 228. The hire charge for period from 5 September 2013 to 4 September 2014, due from Christ the King under the hire contract, invoiced by Built Offshire as agent. So that's D, a hire charge for a period. For the other 4 relevant invoices, the judge says at 449 little 2, so just over on the next page, that they are the rent payable on for particular dates. And we can actually see the precise descriptions set out in the college's counterclaim for restitution. At the same bundle, core bundle, tab 15, page 331. I'm sorry to jump about a bit. You see on page 331, under the heading Particulars of Payments to SFM, those are, you've got invoice number 0008 and then 3 more. Those 4 are G, H, I and J. So those are the other 4. And so you can see the narrative on those invoices pleaded here as part of the counterclaim, the college's counterclaim for restitution. They're building rent for particular periods, or hire for first 2 building rent, second 2 sixth form hire for particular periods. It's because the buildings were used as a sixth form centre, that's where the sixth form comes in. So the judge did actually have a reason based in the facts and the evidence for treating these payments as payments that were referable to particular periods. It was the college's own claim, and indeed the documents made it clear that that's what they were. That's what they were understood to be anyway. And then going back to the judgment, now on page 230, just coming to the end of that section, at paragraphs 454 and 455, the judge allows the college's counterclaim on that basis, subject to defensive change of position, which he then considers and finds justified. And as I think my lady and my lords have well in mind, you can see the figures for the change of position on page 239, paragraphs 482 and 483, which is 5.7 million plus VAT, plus 125,000, plus some more that the judge didn't quantify because he already had enough. We then move on to paragraph 493 at page 243. The judge is looking at the question about that there was a question whether there's a surviving asset that defeats the defence of change of position, and he makes the point at 493 that he's accepted the college's case that the realisable value was negligible. That's all part of the assessment of finance lease. There's no real surviving asset, and then 494. In any event, SFM had sold participation in any residual interest to others. And then it concludes on the change position defence of paragraph 499, just to identify that in the judgment, page 245. And he then comes to the issue in this appeal, paragraph 500, and I know you've read paragraphs 500 to 504. But what the judge explains in paragraph 504 is, I hope, more comprehensible in the light of the earlier parts of the judgment that I've now shown you, because what he explains is that the benefit that SFM actually transferred to the college, bearing in mind that the contract was void, was the use of the buildings for a period. That's what the college actually got, remembering that the contract was void. And my learned friend's submissions, I'm afraid, go wrong when they say, well, you've got to treat this as a transaction which was a finance lease, which was therefore an acquisition, because the college didn't get the building. That wasn't the transaction. That was the intended transaction, but that was void. And so therefore the question for the judge was to identify what had SFM received in exchange for conferring on the college the use of the building for the relevant period. That was the question for the judge. And once you see the other findings and understand that that's the question the judge was answering, in my submission it is plain that the judge's answer was right. What SFM received in exchange for the use of the buildings was such part of the payments for those periods which was referable to the use of the buildings, and the judge quantified that by reference to the true market value. So there was no claim for the first period when the college was paying. But in the whatever the college paid in the first period, the rest of it was not for the use of the buildings. The rest of it was for the finance transaction which turned out to be void. So it was not for the use of the buildings in the second period. The college was not barred from claiming every penny that they paid to SFM, but that claim failed because SFM had a valid change of position defence, and there's nothing unorthodox or unusual about that. But the effect of it is that the transfers made pursuant to the void contract are treated as containing two exchanges of benefits. On the one hand, you've got our restitutionary claim, which was only allowed in respect of the exchanges that are the equivalent of the operating lease part of the contract, because that's the benefit that the college ended up getting, was the benefit it could have got on operating lease. That's the part that we are therefore allowed to make a restitutionary claim for, and the answer to that is, well, they paid for some of that, but not for the rest. And it's not for the rest is why we still had a claim. The other benefits of lending them money, which is what it was held that the transaction also included, was effectively a loan. Well, we don't get a claim for restitution in respect of that, because that would undermine the policy of the legislation that made the contract void. So we had no claim to restore the benefit that the college, well, in the end, and another reason, of course, is the college in the end didn't get the benefit of the loan because it all got undone. So there's two reasons why there's no restitution claim for those. So there's no restitution claim for those. So it would be quite unjust to say, in circumstances where we've got no claim for that potential benefit, you may say it's not even a benefit because it didn't happen, to then say that what was paid for that benefit comes into account as if it was received in exchange for the benefit for which we do have a claim. So what happened here, of course, is that SFM has ended up substantially out of pocket on the transaction, as you know, because of the way the judge divided up the benefits transferred on either side. And by this appeal, the college is seeking to rub salt in the wound by arguing the judge was right to make that division of benefits for one purpose, i.e. to stop us having a claim for the whole benefit of the finance lease, but wrong to make the same division for another purpose. So the college is really asking now for this court to overturn a consistent finding and turn it into an inconsistent finding in order to make sure that we are punished as much as we could possibly be for entering into what turned out to be a void contract. And my lady and my lords may have seen in one of the authorities that it's not the policy of the law to punish persons who enter into what turn out to be void contracts with public authorities. But that's really what the college is seeking here, and in my submission it should be resisted. And as I've submitted, that division of benefits is ultimately a determination of fact or if not a determination of pure fact, it's an assessment. It's an assessment of the application of a legal concept to a whole factual situation. And that is very much within the category where this court only interferes if the judge has made an error of principle and does not simply rehear the issue. We also, of course, rely on the consequentials judgment, which is in the same tab. And I'll just briefly say what we draw from the relevant paragraphs in that. Page 258, paragraph 22, there are limits to the netting off process, and that proposition is, of course, accepted by my learned friend. And my lady, my lords, we say that's a rather critical concession, because once you accept there are limits to the netting off process, then it's for the trial judge to assess how the facts fit with those limits. And then 23, the judge relies on Goss and Chilcot, and I think my lady friend accepts that what the judge did was to apply the approach of Lord Gough and the Privy Council in Goss and Chilcot, but to say that he was wrong to do so because it's been held, he says, not to apply to a void transaction. I'll have to go to the authorities on that, but my lady, my lords, I say he's wrong about that. It's a perfectly acceptable approach. Paragraph 24 makes clear that he is doing the same here. Paragraph 25, the judge makes an independent point that the result for which my learned friend contends would be inconsistent with the change of position defence, and we rely on that point as an independent justification for the judge's result. And in paragraph 26, the judge addresses unconscionability header, and that is the application of well-established principles to the facts of this particular case. Unconscionability, as I think my learned friend accepted when it was put to him, is the touchstone of the restitution to be remedied, and the judge applies it there. So, my lady, my lords, that was what I wanted to say about the judgment, and then I propose to turn to the authorities. So, I invite you to close the core bundle and go back to the 90s and the swaps. In authorities bundle 1. I'm going to try to restrain myself from constantly repeating the refrain, but that was in the context of a swap. But perhaps if I do manage to restrain myself, which I may not, my lady and my lords will take that as read when we look at what was said in this case.
I've just written it down.
Thank you, my lady. I've now rather tired myself to try not to repeat. I'll just run through, taking what making the points I feel I should from these judgments. Obviously, bearing in mind that we've looked at chunks of them already. So tab 7, Mr. Justice Hobhouse, Islington, and Sandwell. And page 905 of the report, I do rely on a point that my Lord Justice Popplewell pointed out at 905J, that the contract in this case provided for the payment of net sums. So netting off is perhaps rather more straightforward. 911 of the report, letter B, makes the point that the Sandwell case was not concerned with defences of change of position, although they had been pleaded, but the preliminary issues being considered by Mr. Justice Hobhouse did not concern them. I then move on to 929, where at letter C, Mr. Justice Hobhouse makes what I submit is a significant point, that quantum merit is not a relevant benefit at all. It does not arise under the relevant contract. It's awarded by the court independently on the basis that there is no effective contract and has been no contractual compensation. And we say that's an important point. You can't net off quantum merit awarded by the court against a benefit that actually was transferred, particularly not in some non-monetary form, because the two are different things. They're completely different things. Of course, they may end up being the subject of some form of set-off in a judgment or a counterclaim, but they are not fungible items that can be simply netted off at an early stage of the analysis.
So I'm not sure I'm understanding this point. Are you saying that because they require subsequent valuation, they can't be netted off, although they can be taken into account under the counter restitutionary principle? So I'm not really understanding what your point is about them being quantum merit.
My point is there's a big difference between netting off payments going either way under a contract which requires them to be netted when they're paid, and then netting off the other payments under that contract on the one hand, and on the other hand seeking to net off a non-monetary benefit on the basis that the court has awarded a quantum merit for it, and therefore it's quantified it to that extent.
Well, obviously there is a difference.
Yes.
The principal one being that in the second case you have to wait until the amount is ascertained by the court if it's not agreed. But apart from that, how does it affect the principles to be applied?
It affects where it comes in the analysis. It shows that to say that the starting point is you can only measure the enrichment by just netting everything off. It is not the same exercise when one side of the equation is a service which may or may not turn out to be the subject of a quantum merit award by the court. They are different beasts, and that's the.
But you still net them off.
You can ultimately net them off, but as I'm saying,
as the judge did in this case for the period prior to 2017.
Yes, my submission is that the difference is relevant to the stage at which you might do it and to where it fits into the analysis. It fits in at the end, after the court has made its award in relation to the second part. You've already assumed that A, the contract has gone, and B, the court has made a restitutionary award. And so it doesn't make sense to say, well, when we look at what happened on the facts, we net those two off first before assessing what happened. It makes much less sense in that case than it does. I agree that, of course, one could do it, and that I'm not saying you couldn't do it, but I'm saying that in terms of what appears to be the most natural analysis, it's different in that case for the reason given here by Mr. Justice Hobhouse. So I don't go too far with this. I don't say it makes it impossible, but I do say it means that what's the natural stage to do it is quite different.
I'm sorry, it's my fault. I'm still not quite understanding how this fits into the analysis. On one analysis, whether it's as a result of the court doing the valuation or whether it doesn't need that ascertainment because it's a sum of money, you're still netting off in the sense of identifying a net benefit. So the netting off goes to reduce or extinguish the benefit, which was the way that Mr. Justice Hobhouse seemed to be looking at benefit here. It was looking at extent of enrichment, says that several times. Now, you seem to be saying something different. In those cases in which it does fall to be netted off, what do you say the process is, or the staging? You first of all look at the benefit to the other side. Then
I am saying something different. Absolutely, Modular. I am saying that there is no rule of law that the netting off of counter restitution takes place at the stage of assessing what the amount of the enrichment. I'm not saying you can never do it that way. I'm not saying that Mr. Justice Hobhouse was necessarily wrong to do it in this case, although if I have to say that, I will. I'll come to the other authorities later. But I am saying that there is no rule of law that that's the only way to do it, and that while that may be, or may not be, this case doesn't raise the question, an acceptable way to do it in a swap contract, it's not an appropriate way to do it in a different kind of contract, such as the one that the judge was dealing with. So I'm not accepting as a starting point that there is some rule of law, that the way Mr. Justice Hobhouse did it in this case is the only way it can be done. It is quite unnatural in my submission to treat what is often called a set-off or a condition for the granting of of restitutionary relief as if it was the measure of the enrichment. Because if it's the condition for the granting of relief, then the premise is that there is a restitutionary claim in the first place. It doesn't make sense. So my submission is that while it may be, you certainly reach the same result in many cases, and it may be even that it is the appropriate way in a swaps case. I'm not arguing a swaps case, but it certainly is not the appropriate approach in all cases.
So the stage at which you say it falls to take it into account is at the end of the exercise when you're deciding whether to grant the relief you would otherwise grant.
Yes, I'm saying that certainly in our case, the appropriate approach is to go through the stages that the judge went through, which is to say, was there a benefit conferred on the college? Yes, namely the use of the buildings. That's the benefit conferred on the college. Was that conferred at our expense? Yes, we paid for it, conferred it. The judge, it's unjust because it was conferred under a contract that turned out to be void, the unjust factor. I've got no difficulty with my learned friend's approach to the law on that. And the judge then quantifies it and then says, but as a condition of giving you relief for that, you've got to give counter restitution. And the counter restitution is for the periods where the college paid money referable or attributable or in exchange for the use of the building, you get nothing because you were paid. That's counter restitution. You've got to give that money back. But for the periods in which the college paid nothing towards the benefit, you don't. And so that is the court imposing the condition of counter restitution on my client's restitutionary claim. And in order to impose that condition, which is the counter restitutionary principle, that is a condition of restitution being granted, there may be many approaches. And I don't mean by that there's no principles involved. But the fundamental principle, the counter restitutionary principle, is that it's a condition of a successful claim for restitution that counter restitution is given. And depending on the underlying facts, there are different ways in which the court can impose that condition.
Sorry, just to turn you further, did you indicate that you agree with Mr. Watkins that the second stage or the second element of Lord Staines' 4 stages of unjustness is a category case? It's the categories in which claims for unjust enrichment may arise, which are the unjust factors, and it's limited to that. It doesn't impose a separate question of whether the enrichment is unjust.
Yes, I'm not aware that that question has any impact on the appeal, and I am quite content to accept that that is where the law now is, on the basis of the authority that Mr. Watkins showed you.
Thank you.
To some extent, that plays into the difficulty that any court has faced with almost any restitutionary claim, certainly one that raises any difficult questions, is that the philosophical underpinnings are so contested in the literature. And my submission is that the way a court should approach that is to identify the clear principles, such as the counter-restitutionary principle as I have formulated it. And on the basis of those principles, ask the question, has the judge applied them correctly, or within the judge's rights, as it were, to the facts of the case, and not seek unnecessarily to formulate new principles, such as the only way this can ever be done is to treat the counter restitution condition as going to enrichment and therefore being done at the very first stage, which really are not, they're not called for. I mean, they would, obviously my learned friend says, well, it would make a difference in this case, and perhaps it would, but there is no basis for saying that that's the approach in every case.
And every case will, in the end, you look at its facts, and what may not be helpful are very strict lines. Principles, certainly,
Yes.
not strict lines.
Yes, absolutely, exactly so, my lady. And of course, the principles develop incrementally as it really, when it is necessary to do so, when a real clash arises. But this actually isn't a case of that sort. So that's my submission on how it works. And then if I may just carry on through Mr. Justice Hobhouse to page 940 in the report. I think you were asked to read this passage, the end of the foot of 940 over to 941. And that key passage only applies to contract for exchange of monetary sums. Sorry, my lady. The statement, but specifically the statement at 941E, these words from D to E. Accordingly, the position was analogous to that of a running account between the two parties. Only one underlying transaction was involved, the first Samwell swap contract. The successive payments merely altered the location and extent of the enrichment which existed from time to time. The earlier payments had long since ceased to give any cause of action to either party. Those statements, in particular that last sentence, could not be made in our case, which shows puts a little bit of flesh, I think, on the bones of the point that I'm trying not to repeat. And the statement at 941H to J, on which my learned friend relies, is also one that applies where there is an exchange of cash payments which are referable or attributable to each other. I move on, if I may, to 948. F to H, same point, depends on a running account analysis. And I then was going to go to the Court of Appeal. I mean, maybe before I should do so in response to the questions I've been asked on this, I should make clear I do accept that Mr. Justice Hobhouse is most naturally read, partially Professor Burrows is most naturally read as supporting the idea that, at least on these facts, you do the counter-restitutionary set-off at the first stage. But he doesn't, he nowhere gives a statement of principle. My learned friend has shown you a lot of his words. He nowhere produces a statement of principle that is to be derived from the fundamentals of unjust enrichment. He is really doing it on the basis of how he sees the facts before him. And then in the Court of Appeal, where they looked at the Islington case, it's notable that Lord Justice Dillon did not look at the case in the same way as some of the statements you've seen from Mr. Justice Hobhouse. And in particular, in the judgment, in Lord Justice Dillon's judgment from page 957 of the report through to 960, so that's a long passage. I'm not going to ask you to read it all now, but he characterises the claim as being a claim for the restitution of the initial 2.5 million payment in that swap, because these were slightly unusual swaps with an initial payment at the beginning, less such parts had already been repaid. So his focus is very much on the 2.5 million as being the origin of the claim, whereas Mr. Justice Hobhouse focuses on the balance at any given time. And that different focus may be reflective of the interest cross appeal, which the Court of Appeal decided by bringing the date for interest forward to the date when the 2.5 million was paid. So there is a difference there. And that results in the discussion at 960H to 961E, which my learned friend invited you to read. And what you saw there was that the old case of Rugg and Minette, which was approved by the House of Lords in Fibrosa and approved again by Lord Justice Dillon here, a payment was severed by reference to the subject matter that it was paid for, and the consideration was held to have failed for only part of a single payment. And Lord Justice Dillon said that you could do the same with exchanges of money to reach the same result as Mr. Justice Hobhouse had reached. So that exercise of severance is, on the basis of this passage that my learned friend showed you, clearly an exercise in judgment as to the facts and as to what particular subject matter a particular payment was made in respect of or in exchange for. And that's particularly clear from the reference at 961A to B to the initial payment in advance, where talking about the Fibrosa case, you can see that I think it's a reference back to the description of Rugg and Minette, that a particular payment had been on account of purchases generally, but the court severed the consideration and held that the parts attributable to the cast which had not been filled had wholly failed. 961D, which I think is part of the passage you've read, makes it clear that the reasoning here applies in what Lord Justice Dillon calls a purely financial matter. So the general rule is the one that's explained at A to B, that severance is possible, and then it is even possible in a purely financial matter. And at F to G, Lord Justice Dillon recognises that the situation may be different, where consideration for money is something other than money, and it's not severable. So it becomes a more. So what he recognises at F to G, which I think maybe after you stopped reading. No, I'm sorry. I'm on the next page. 962. I'm so sorry. 962 F to G is the passage I have in mind. So having gone through the authorities that show that severance of a payment is possible, Lord Justice Dillon then says at 962 F to G, it's unnecessary to explore in this case what intricacies there may be in applying the concept of money paid for a consideration which has wholly failed in other cases where the consideration for a payment of money is something other than the payment of other money and is not severable. So if it's not severable, it becomes a much more difficult situation. And contrary, I think my learned friend made a submission about that. And contrary to his submission, I say, my lady and my lords, that is a reference back to the discussion of Rugg and Minette and the possibility of severance. And what Lord Justice Dillon is saying is where severance is not possible, and where you don't have money on both sides, then you may have a more difficult problem with which he does not have to wrestle. So that's what I say is going on in that passage, which I think you were taken to with a slightly different interpretation of it. Now, my learned friend then also relied on a passage of Lord Justice Leggett at page 967 H to J, but I would draw attention to a sentence that I've just referred to without giving you a reference earlier, which was 967 E to F. It is not the policy of the law to require others to deal at their peril with local authorities. I think I may have slightly embellished that for my own purposes, but I think that's the sentence I had in mind. And I also draw attention then to E to F. Any system of law, and indeed any system of fair dealing, must be expected to ensure that Islington do not profit by the fortuity that when it became known that the contract was ineffective, the balance stood in their favour. In other words, they also should not be unjustly enriched. And then at H to J, that's what my learned friend relied on. But then if we also look at 968C, Lord Justice Leggett went on, in my judgment, that formulation from Mr. Justice Hobhouse is wholly accurate, provided that the contract in question is not a borrowing contract. And of course, that's exactly what the contract in our case turned out to be. Borrowing is exactly what it was. And then finally, in respect of this case, I think your lordships, my lady, have been already told that there is academic debate about it. And I think my learned friend acknowledged that Professor Edelman, now Justice Edelman, and Professor Bant, for example, clearly take the opposite view of what Mr. Justice Hobhouse should have done in that case, and opposed to my learned friend's submission as to what principle should be applied if we have to decide one way or the other. I do want to just go back, though, if I may, to Professor Burrows, as he then was, in Authorities 3, tab 30. My learned friend invited your attention to the paragraph by the second hole punch on page 570 of the book.
Sorry, which page?
It's 915 of the bundle.
Thank you. Yeah.
570 of the book. And you were looking at the paragraph. It begins, "It seems clear." And my Lord Justice Popplewell was putting to my learned friend that the last sentence on which he relied doesn't seem to follow from the first part. It also is inconsistent with the remaining 3 paragraphs. I don't know whether the court may well have read on in any event, but those remaining 3 paragraphs are much more consistent with my case on the law, or at least not my learned friend's case, where Professor Burrows says some obfuscation of the true nature of counter restitution may have been caused by Mr. Justice Hobhouse's judgment at first instance in Kleinwort Benson. Goes on to describe that. And then on the next page, this might be interpreted as indicating that Mr. Justice Hobhouse viewed counter restitution as concerned with the defendant's enrichment, rather than being a counterclaim set-off defence based on the claimant's unjust enrichment. However, it's submitted that by referring to net enrichment, Mr. Justice Hobhouse was not suggesting that one was here concerned to deduct the defendant's loss from the enrichment to receive. Rather, he was pointing out that one should net off the claimant's entitlement to restitution against the defendant's counter-entitlement to restitution. So, Professor Burrows seems to be even trying to suggest that Mr. Justice Hobhouse didn't mean it. Now, I've already indicated, I'm not saying that's the natural reading, but it seems to be an attempt to make what Mr. Justice Hobhouse said consistent with what Professor Burrows thinks the law either is or ought to be, which is not in my learned friend's favour. And the next part of this goes through that, and then the last paragraph on the best interpretation. Therefore, Mr. Justice Hobhouse was not contradicting the correct analysis that counter restitution is an unjust related defence, recognising a counterclaim set-off, based on the claimant's unjust enrichment rather than being an enrichment related defence. So, not only does that one sentence that my learned friend rely on not follow from what goes before it, but it's actually directly contradicted by the whole of the rest of this passage. So, my lady, my lords, as I indicated, if it's absolutely essential to do so, I'll say that Mr. Justice Hobhouse's approach was wrong. But my primary submission is this court has no need to comment on that, because Mr. Justice Hobhouse was not setting out an approach which was even on his view of the matter intended to apply to all cases. But simply the approach that he held to be applicable on the facts of that case. And clearly, if you were attracted to the idea that it was essential to say which element counter restitution goes to, then I would have to say that that in line with several of the most qualified writers, I submit that Mr. Justice Hobhouse was wrong about that. But as I say, I would invite the court not to interpret Mr. Justice Hobhouse as actually entering into that debate. It's not needed. My lady, my lords, closing 3 and going back to Authorities 1, I do rely on Goss and Chilcott. So I think my learned friend accepts that the judge was applying the approach in Goss and Chilcott, although he then goes on to say that he shouldn't have. So this is an important decision for our purposes. It's tab 9 of Authorities 1. Just to summarise again the relevant facts, including the decisions on the appeal, the plaintiff company had lent $30,000 to the defendants on a mortgage. The mortgage instrument had been amended by someone who was held to be the company's agent, so that the defendants were no longer liable under it. The defendants had made 2 interest payments but did not repay any of the capital, and the company claimed in restitution for the capital sum on the basis that it had been paid for a consideration that had failed. And the relevant part of the decision starts at page 797, and it's a decision of the Board of the Privy Council, read by Lord Goff. And starting above the letter C is the well-known quote from Lord Simon in Fibrosa, that when one's considering failure of consideration, the quasi-contractual right to recover money on that ground is, generally speaking, not the promise which is the consideration, but the performance of the promise. And then a passage that I think you were asked to read to yourselves from letter E down onto the next page. I rely on all that, and as you saw from that, the interest payments did not affect the question of total failure of consideration, because the interest had a different function to the obligation to repay the capital sum. And at 798A, Lord Goff said it is both legitimate and appropriate to consider the two separately. And I rely on that passage, and I'll say a bit more about it in just a moment. At B to D, Lord Goff says that the interest payments can also be recovered on the ground of failure of consideration. So there are 2 good claims for restitution. And then at letter D, I think my learned friend relies on the statement that judgment would doubtless be given for the balance. But that statement does not help him for 2 reasons. First, the principal point is that Lord Goff is considering a case where there's no defence to either claim. And I accept that if there was no change of position defence available to my client, then of course you'd end up with a balance. So there's nothing there that's inconsistent with my case. And the lesser point I make about that is that the board is careful here not to endorse or apply in a different context all of the reasoning of the Swaps case, that the claim is only for the balance. Indeed, the analysis leading up to letter D is inconsistent with the idea that you start with the claim for the balance at the very beginning. The way it's put is that judgment would ultimately, I've added the word ultimately, but the way it's put is that judgment is given for the balance. And that's the ultimate step after considering the 2 claims in the way that Lord Goff does in this passage. And then at E to F, Lord Goff says that even if part of the capital had been repaid, the balance would still be recoverable on the ground of failure of consideration, because it could be apportioned without difficulty. So apportionment very much in favour in this judgment. So just to return to the point at 798A to B, and perhaps to labour a point I've already made, our case is that the effect of the judge's findings of fact in our case is that the college's payment under the hire contract had 2 different purposes or functions. One was the lawful one, use of the buildings for the period to which the invoice is related, which was not just lawful, but it was also the benefit the college actually got. And the second was repayments of capital and interest of finance, which the judge held was inherent in the contract, and which was both unlawful and a benefit the college in the end did not get. So those were findings of fact that were open to the judge, and we say they were not just open to him, but right.
Just before we leave Goss and Chilcott, what do you say about Mr. Watkins' submission that this doesn't apply to our case because it's not a case which was void from the outset? I think
yes,
was his suggested ground of distinction.
It is, and I'm just about to come to that.
Oh, sorry.
No, my lord, your lordship's right to ask the question. And he makes that submission, as I understood it, not on the basis of anything said in Goss and Chilcott. Obviously, Goss and Chilcott is a voidable case rather than a void case, and I accept that. But there's nothing in here that would suggest it's different, because the unjust factor is the same. The unjust factor is the avoidance of the contract, and the payment therefore being made without consideration of the contract. So there's nothing in Goss and Chilcot that supports my learned friend. Where he gets that from is Guinness Marne. And so I'm going there next in the next tab to explain why that's wrong. Just incidentally, no, actually, let me come up a bit. It's 227 to 228 in Guinness Marne. My learned friend showed you, and he submits, as my lord puts to me, that shows that Goss and Chilcot doesn't apply to void transactions, but it does not show that in my submission. Indeed, in my submission, Lord Justice Morritt is saying the opposite at letters E to F on page 227, where he says the second theoretical basis on which the council tries to justify the distinction between an open and a closed swap is by reference to the principle of severability or apportionment consideration. Such a concept was referred to by Lord Wright in Fibrosa, and then he refers to Rugg and Minette and Westdeutscher, and then he says the principle was further explained and applied in Goss and Chilcot. Now, just stopping there, he's describing the principle which exists, and clearly accepting that it exists on the basis of the authorities that I rely on. And he then says that Mr. Bayard sought to apply that principle by severing each 6-monthly swap, both from the overall agreement and from each of the others, and thereby to draw a distinction between the open swap, where it was suggested there was a total failure of consideration with regard to the outstanding swap, and the closed swap, where there was no such failure because it had all been performed. But a distinction can't be drawn on those lines. And he goes on to explain that on that basis each 6-monthly swap would be severable. The relevant consideration for each was the performance of the obligation each party thought it was under. Then each swap would be fully performed. Neither party could recover from the other during the term or otherwise. If, on the other hand, the consideration for each was the benefit of the contractual obligation, then there was a failure of consideration in the case of each swap either before or after it elapsed, thereby entitling the loser to recover the balance under the closed swap as well as an open one. So it doesn't, and neither horn of the dilemma justifies a distinction between a closed swap and an open swap. As Mr. Leggett submitted, the proposition proved either too much or too little. Well, my lady, my lords, if the position was that there was something in the law that meant that this analysis did not apply to void contracts but only to voidable ones, that would have been a rather shorter route to the conclusion. And one wonders why it wasn't submitted by Mr. Leggett or mentioned by Lord Justice Morritt, if that was the position. So my submission is it just doesn't say that at all. I don't understand, I'm afraid. It may be my fault, but I don't actually understand, perhaps, how my learned friend says that you get out of that the proposition that this doesn't apply to void contracts, but only to voidable ones. What you get out of it is that severance does not justify a distinction between an open swap and a closed swap, because you either end up, if you sever, you either end up saying that the open swaps are in one position or the closed swaps are in the other position, but you don't end up distinguishing between them. The premise of all of that is that severance is a potential route, but it just doesn't make the distinction that council wanted to make. Now, I did just want to show you a couple of the equitable set-off authorities that my learned friend, or particularly one that he'd cited, which he then didn't go to. One of the, and maybe I'll start with the skeletons, because he didn't develop this, but there's a debate in our skeleton arguments about an analogy with equitable set-off, and as my lord Popplewell pointed out, there is potentially an analogy where unconscionability is the touchstone of both, and close connection is the touchstone of both. The phrase close connection is not the phrase in restitution. The relevant phrase is in exchange for, or perhaps attributable to, or referable to. But there's clearly an analogy. In the supplemental skeletons, my learned friend, I can show you my learned friend's supplemental skeleton, which is at tab 3. You still have it for the bundle. laid into any suggestion that there might be a useful analogy, and particularly perhaps seeing that as me trying to say that this was all more or less discretionary. And at 14.2, page 41 of the bundle, he says, in the present case, the payments by the college in the earlier years were plainly sufficiently closely connected to the college's use of the building throughout the period. And as Lord Justice Ricks explained in Goldhoff, where a case concerns a claim and a cross-claim arising out of the same contract, although that fact is not in itself enough to ensure an equitable set-off, it's on the whole likely to take a special rule excluding set-off, such as the rules about freight, rent and cheques, and now direct debits, to prevent a set-off. And then my learned friend says, there is no special rule relating to rent, nor is there any rule limiting set-off to claims arising in the same period, and refers to Courage and Crean. And that's slightly peculiar because, of course, the passage he's just quoted makes it clear that there is a special rule in relation to rent, which there is. So if there is any analogy, close connection is probably a slightly looser test than in exchange for, but even there, rent would not normally be such refused as between one, rent due under certain leases of pubs, and two, claims for damages against the landlords on the basis that the leases contain provisions which breached Article 85 of the EC Treaty, as it then was. So it's clear authority on the point that you don't always get equitable set-off, even for cross-claims under a single contract. We say that's a useful indicator, though of course it's not. It's only an analogy. My lady, my lords, in relation to the Singapore case, we make a number of points in our skeleton argument in paragraph 25, and I don't believe I need to add to those. It is obviously a case on particular facts, and in any event, not binding. I don't think I need to say more than that on that. My lord, my lady, if you just excuse me for a moment, I just want to see if anyone on my side thinks there's something else I need to say. No. My lady, my lords, is there any point on which you believe I might be able to assist?
Thank you very much. No, thank you. Well, I'm not going to ask you to squeeze anything you want to in 5 minutes. Would you like overnight to have a bit of a think and then start again tomorrow?
I'd be grateful for that.
Of course. Should we start 10:30 tomorrow?
My lady?
Yes.
And Mr. Sanzi might be going to come back to us on mean profits. Never know.
In that case, if I may not have totally sat down, I will look at mean profits overnight.
Fine. Well, then there may be something more before you start again at 10:30 tomorrow. Right. Thank you both very much indeed. 10:30.